Well, good afternoon, ladies and gentlemen. We will commence this session. I welcome you all to the festival, and I have some housekeeping matters to refer to. There will be some people joining us online as well as you, the live audience, and some people joining from libraries around the place. Libraries are good. They have books, and books are good. We acknowledge the Gadigal people of the Eora Nation as the traditional custodians of this land, and we pay our respects to the elders past and present, and to any First Nations people presently with us. I'm Nicholas Cowdery, and I'm delighted to welcome you to the Metcalfe Auditorium for this discussion with our panellists, whom I will introduce in a couple of minutes. These are the matters that I'm asked to tell you. Please mute or turn off your phones before we begin. Please don't record the session. If you are taking photos, please turn off the flash. You'll frighten the panellists. Feel free to share on social media and tag us on Facebook, whatever that is, and Instagram, whatever that is. The tag apparently is @BadCrimeSydney, or with the hashtag #BadCrimeSydney on X, what used to be Twitter. Mr. Musk's thing. And the final one is, so that you can hear more from the panel of very distinguished people that we have this afternoon, the festival is trialling not having questions from the audience. There's been feedback from previous festivals, and people are more interested in hearing what the panellists have to say, apparently, than what their fellow attendees have to contribute. But you're very welcome to talk to the panellists outside afterwards, and there will be some book signing opportunities for you as well after 1 p.m. But if you familiarise yourself with their appearance and tackle them outside, I'm sure they'll be very happy to answer any questions that you might have. I'm, as you may or may not know, a former Director of Public Prosecutions for New South Wales. I retired from that position 13 years ago, having been in it for 16 and a half years. But I've been involved in criminal justice one way or another for 55 years. I know I don't look that old, but you should see it from my side. In that career, or careers, I've had the great pleasure of meeting many people connected with crime in one way or another, and I will introduce our panellists who have that distinction. Starting over on the end here is Mark Tedeschi, AMKC, who is a barrister and former Senior Crown Prosecutor for New South Wales during my time as Director of Public Prosecutions and thereabouts, and as well is the author of 4 true crime books, all of which are available outside on the bookstand. Eugenia, Kidnapped, Murder at Mile Creek, and Missing Presumed Dead. Eugenia doesn't seem to be on the... Oh, yes, it is. All 4 of them are out there. All 4 books are available, so you can collar mark for signatures if you wish. Michaela Maree, next to me, is a former juror. She has had the experience of serving on a jury, and she works with the Homicide Victims Support Group, which is a support group for families and associates of victims of homicide, which does fantastic work, I know from my own personal experience. And she is a trauma and bereavement counsellor. with the Homicide Victim Support Group. Next to me is Malcolm Knox, journalist and author. He's the author of more than 20 books. I won't give you the precise number, it'll make your head spin. Both fiction and non-fiction. The book that brings him onto this panel really is the book Secrets of the Jury Room, which describes his experience as a juror in a trial that had quite a number of lumps and bumps in its course. That book was published in 2004, but his most recent book, The First Friend, is a work of fiction but sort of connected with history in Russia, which is being reviewed widely in publications at the moment. And that book is actually available outside in the bookshop if you want to collar Malcolm and have a discussion with him about that. And finally, on my left is Professor Jane Goodman-Delahunty of Newcastle University, who is a lawyer and a cognitive psychologist engaged in research into many aspects of the criminal law. She has published a number of books, co-authored a number of books, published a vast number of research papers, as you might expect from a prominent academic. And one book that you may be interested in, unfortunately it's not available outside, but you could find it for yourself, is a book called Juries, Science and Popular Culture in the Age of Terror, which is a description of 2 live jury experiments that Jane and Professor David Tate carried out, where members of the community were empanelled as role-playing jurors for a trial of a set of facts that were established for that purpose. Very interesting if you want to look for that. So that's our panel, and I will hand over to them soon. But first I want to make a few comments about juries. Juries have a long history. We inherited the system from England when the colony of New South Wales was established, or soon after it was established. And the English history goes back to the 13th century, really. Juries did not come from Magna Carta. I have to say that right at the outset, because so many people seem to think that they did. Magna Carta was responsible for a lot of other things, but not juries. But interestingly, it was around the same time that developments were occurring to lead to the establishment of the jury as we would understand it these days. And I'm not going through all of that history because it's very convoluted. And it led to development of the grand jury, which was a body put together to assess whether or not somebody should be put on trial. We don't have grand juries. We used to have committal proceedings in New South Wales, which served a similar purpose. We now have a more streamlined system in place now for dealing with that. But then the petty jury, which became the jury that sat on the trial. And way back, juries were actually selected from people who had some knowledge of what had happened. So we've come full circle from a time when juror qualifications were, yes, they knew a bit about the crime that was alleged and they could bring their own judgment to bear, to the situation we have now where jurors are selected because they know nothing about what happened, or that's the presumption, and they learn about it only from evidence which is legally admissible in the course of the trial. Juries have been described in many different ways, both positive and negative. The High Court, in its judgments over the time, have described juries as a little parliament, a bulwark of liberty, a protection against tyranny and arbitrary oppression, protection against oppressive laws and supine judges, protection against compliant, biased or eccentric judges, heaven forbid, and protection against the corrupt or overzealous prosecutor. I think those are all positives. The High Court is described as a guarantee against the arbitrary determination of guilt or innocence, and an important means of securing a fair and impartial trial. Now, that's not to say that juries are perfect by any means, and the form of the jury varies from place to place across the world. It's not only the English common law countries that have juries, they are in existence in inquisitorial systems as well, the continental systems of justice. We're most familiar, I suppose, with the situation in England and Wales, where these days about the only person who is exempt from jury service in England and Wales is the King. Everybody else can be called up, and we have the situation now in England where lawyers, judges, yes, judges can be called for jury service. Everybody is eligible for jury service. In Germany, they have a system of appointed lay people sitting with a judge. In Sweden, there are lay magistrates who sit in the equivalent of the local court. In Scotland, they don't have 12 jurors, they have 15, just to be different. And 3 verdicts, guilty, not guilty, and not proven. And the verdict is returned by majority verdict out of 15, 8 out of 15 or more. In the United States, as you may know from television, there is a huge amount of time taken at the beginning of a jury trial for what is called the voir dire examination of potential jurors to see the extent of their knowledge of events that are going to be tried and any prejudices that they may bring to the making of their decision. In Norway, for instance, there are 10 jurors. You only need 7 for a majority verdict. And New Zealand is very similar to ours, but there is some degree of jury vetting that may take place before the trial begins. Juries are being created in other countries. They're coming online. In Spain, they've recently been introduced, and they must provide reasons for their decisions, which does not happen in our system. Jurors do not provide reasons. In Russia, believe it or not, there are jury trials. I don't think we ever see them broadcast, but they started about 10 years ago. And the statistics show that there's a higher acquittal rate with juries than there is with trials before single judges.
Surprise.
Surprise, surprise. Very complicated in South Korea. Juries were introduced in 2008 for only serious crimes. The accused person must opt in for the jury. A simple majority out of 9 is required for capital punishment or life imprisonment cases, 7 jurors in other cases. It's all a bit complicated. In Japan, in 2009, they reintroduced 6 representative jurors sitting with 3 judges. So it's all a bit of a mix. It's called the Saiban-in system of juries. And in Argentina, which is very similar to our system, they must have 6 men and 6 women, and there must be indigenous representation on the juries in Argentina, which I think is quite interesting. So the situation in New South Wales is that we have 12 jurors There may be more empanelled in trials that are going to take a long time, just to allow for attrition through illness and other events. There must be a unanimous verdict, but there is a provision for a majority verdict of one less than the total number, and provisions in place for that. And it is possible to have a trial by judge alone, without a jury. But that must be with the consent of the accused person, and the trial judge must determine that it is in the interests of justice that the jury be dispensed with. And that might be because of enormous pre-trial prejudicial publicity that jurors would not be able to ignore when they're carrying out their task. It might be because there is enormously complex evidence to be examined. I think that's a bit of an insult to jurors. If the counsel and judge are doing their job, then everything can be explained to jurors, in my view. Or it might be, for example, where there's just a very small area of the case which is in dispute, and before a judge alone it can be conducted more efficiently by accepting all the stuff that's not in dispute and then just focusing on the material that is being disputed, things like that. But the vast majority of the trials that are conducted in our district and Supreme Court are conducted before juries. It's a small number, but maybe a growing number of trials by judge alone. So with all of that, I'm going to turn first to Malcolm with a question, and then to the other panellists in turn if they wish to comment on it. But before I do that, the book that I referred to, Secrets of the Jury Room, was published in 2004 after a bit of a hiccup in the publication process, apparently. And I'm just going to read a paragraph from the introduction to the book. This is from Malcolm. The words, I hope, will be familiar to you. Having tried to get out of jury service, having believed jurors must be blithering idiots, too dull or too dispensable to get out of it, having thought that to trust 12 people dragged in off the street was a system 200 years out of date, I'd arrived at a position where I now believed jurors were not only an essential safeguard to liberty, but that being on a jury should be a duty that is almost impossible to evade. I walked out of the court a convert. So Malcolm, are you still a convert, and should juries be retained? If so, why?
Thanks, Nick. Those words are vaguely familiar to me, and I have to preface everything I say by the fact that it was more than 20 years ago that I was on that jury. I feel a little bit out of date, but Jane just reminded me that it's very hard to be out of date in the legal system. Reform moves that slowly. Should there be juries? Look, the ultimate test would be a kind of a make-believe test, which is the question, do they get it right? Do they deliver justice more often correctly than the alternative, which the alternative we think of as judge-alone trial? Of course, we can't know the answer to that. When I was writing the book, I relied to some degree on a study Michael Chesterman had done in 2001 for University of New South Wales, and from memory, one of the figures he had found among the people he had interviewed, which included judges and counsel, it was something like 80 to 85% of judge, defence counsel, prosecution counsel, all three thought the jury had delivered the correct verdict. And obviously it was higher than that, approaching 90%, where you had two of the three thought the jury had got it right. So We can't ever know, but that was a pretty good indicator on the the correctness of the jury's verdict. The other measure you fall back on, which is kind of more the experience I was talking about, is about principles of open justice and community involvement in the justice system, and over time that embeds a sense of confidence from the public as jurors spread their experience around. If it's a good experience and if they feel that they not only delivered justice but kind of received a kind of justice through their involvement as juries, if that is positive, that strengthens public confidence in the justice system. There's always a case for more research. I was relying on a 2001 study, a big 1994 study, and a few overseas studies. I don't know how much research has been done since 2004 on that scale, but you think we're asked to give our satisfaction rating on everything we do. We walk out of a bathroom and, 1 to 5 stars. Not that I'm suggesting that for juries, but there is always a case for more thorough research about juror satisfaction, but juror confidence in the system. And look, I work in the media. I know that there are never going to be front page stories about jury conducts its work quietly and effectively, and everybody goes home. I know the way media works on conflict and sensationalism, but from what I experienced and from what I believe from the research I did, the vast majority of cases have strengthened confidence in the system.
You referred to research. Jane, you've actually done your research. Do you think we should retain juries?
I absolutely agree with Malcolm's perspective and the notions that you set out earlier about the bulwark of liberty and other similar phrases. In part, I suppose, because I grew up in South Africa, in Johannesburg, during the apartheid regime. And like an ex-British colony, once they declared their independence, they actually abolished the jury system in 1969. And it was in part because they wanted to ensure that the apartheid regime had enough force to secure the imprisonment of anti-apartheid activists. And so you see the very clear connection between democracy and jury participation in many situations, and that is reflected in many other communities. And so I did later on move to the United States and actually became a trial lawyer and ran jury trials too, and looked at the system as it functioned there. But in terms of research here in Australia, in about 2008 and 2009, I did a multi-state research project on jury satisfaction, where we actually compared the satisfaction and confidence in justice of people who had gone through an Australian jury experience with those who had turned up at the court and not been impaneled. So they were very parallel in terms of their eligibility. And the actual participation makes the difference. And it really does boost the confidence in the justice system, and is part of a much bigger inquiry into what is called deliberative democracy that looks at citizen engagement with government at all levels and layers. And the petit jury is just one clear example of how citizens can participate in government, have a voice in government, which is critical to the survival of democracy.
Michaela, you've served on a jury. Do you think we should retain them?
Oh, that's a really difficult question for me to answer, quite honestly. my early childhood, I had a dream to serve on a jury trial. I know that's something that everyone seems to want to get out of, but for me, that was something I aspired to have the opportunity one day to do. And my time came, and I was so keen to be, impaneled. I was sitting there, it was like winning the lottery for me. And I must make it very clear that I wanted to either convict someone who the evidence showed was guilty of this crime or acquit someone who had been falsely accused. I didn't mind which way the coin flipped, but in my wildest imaginations, I never imagined that I would be in a trial and the evidence was so compelling that the accused was guilty of committing the crime, but yet bias and prejudice within the jury room prevented us from delivering a guilty verdict. We became a hung trial, and I was elected foreperson to have to deliver that news and be a part of a body that failed to deliver justice and legal recognition of the crime that had occurred. So that impacted me personally in a way that I couldn't ever have anticipated. And it took a lot of shine and hope and belief out of a system that I had revered and respected my entire life. So it's incredible to sit here today and have to convey that truth from my lived experience.
Mark, you've addressed hundreds, if not thousands, of juries in your career. I shudder to think how many there might have been. Do you think we should keep them?
Look, I'm basically a supporter of the jury system. There's something about having 12 people in a room debating with each other, and it tends to round out the rough edges of the individuals concerned, so you get a consensus emerging that has some inherent wisdom in it. I think the main advantage of the jury system is that because it involves community participation, the community has a sense of ownership in the decision. And I can't remember the last time that there was public criticism of a jury verdict. You get lots of criticism of judges' sentencing of offenders. You get occasional criticism of appellate decisions, but it's very rare to have a jury decision that's criticised. It's become a lot more difficult in recent times because of the internet and the availability of information to jurors, and it's really hard to ensure that jurors don't do the wrong thing and make inquiries on the internet. That's created a whole lot of new problems. But by and large, I think that if you have a trial by judge alone, you run the risk of the individual judge having their own prejudice or their own issues from their past lives that they bring into the courtroom. And judges are only people. They're not immune from their prejudices, from their own issues in their lives influencing their decision making. So with a judge, of course, there's nobody there to correct any bizarre views that a judge might have or bizarre approach that a judge might have. Whereas with a jury, you've got, if somebody does have bizarre views, they're likely, if they advance them, to be challenged by the other jurors, and I think that process is a very positive one.
When juries began in the colony in 1823, when the Supreme Court was established, they were initially comprised 7 commissioned Army or Navy officers. That was the beginning of our juries in New South Wales. 7 commissioned officers of the military. That continued for a couple of years, and then it moved in 1825 to 12 citizens who had property qualifications. They had to own a certain amount of property in order to qualify, and of course they were all men. We've come a long way since then, and I'm going to throw up a number of issues and then throw it open to the panel to discuss some or all or any of them. Who should be eligible to serve on a jury? Should we go as far as they have in England and even have judges serving on juries, which seems to me to be somewhat bizarre, but it's happening. It does happen. To what extent should jurors represent the local community, and why? And what action can we take to ensure that that happens? What grounds should be available for people to be excused? Yes, there are a lot of people who try to avoid jury service because of the inconvenience that it causes. We have a process for challenging jurors who might be impanelled as they come forward to be impanelled. Should that continue or should that change? And how should the foreperson be selected? And how should that person conduct him or herself in the jury deliberations? We'll come to you, Michaela, about that. But I just throw those issues open for any member of the panel who may wish to comment on one or more of those aspects.
I think it's undesirable to have a practicing lawyer on a jury because their influence over the other jurors is going to be extreme. If they announce themselves, oh look, I practice in the law, everybody's going to look to them and give them more weight, more authority in the jury room than they possibly deserve. So I think it's undesirable. It used to be that Crown prosecutors were ineligible to serve on jurors and their families as well. That's been changed, and I think again it's somewhat undesirable for any practicing lawyer, particularly a practitioner in the criminal sphere, to be on a jury. As far as the challenge is concerned, we only have a very limited number of challenges to jurors, and when I look back on why I've challenged somebody on a jury panel, it's sheer entire prejudice. That's what all it is, because the only information that you have is what the person looks like. And so what your mind does is your mind says, oh, I know somebody quite well who looks a little bit like that person, so they probably have a similar personality, which of course is totally bizarre. So your process of challenging is probably totally illogical, irrational, and doesn't have the desired effect. And I can tell you that in my early days as a Crown prosecutor, it was still permissible to go to the local pub after a jury trial had finished, and you couldn't go up to jurors, but they could come to you. And let me tell you, the impression that you got of jurors was completely wrong. The ones that you thought were on your side were not necessarily. The ones that you thought were spot on, bright as a button and understood everything were the ones that were the most confused. So it's very hard to actually read jurors, and particularly jurors who don't give you much visual feedback to your arguments. So far as selection of a foreperson is concerned, I can't see anything wrong with the current system that leave it up to the jury to determine that whatever criterion they use is up to them. Generally, it'll be, if somebody says, I've served on a jury before, it'll usually be that person. Or if somebody says, I've been in court before, perhaps not revealing that they were a defendant. They say, oh, well, you know about the system, you can be foreperson. I think that it's probably undesirable to have people who have been convicted of serious criminal offences serving on juries, because they're going to perhaps have a prejudice against the police or against the system or against lawyers. They do have some rules about that, but in my experience, they're often just overlooked. Nobody makes any real inquiry.
You'll be pleased to hear that the Director of Public Prosecutions is disqualified from jury service for life. But my wife was called up once. I managed to organise that.
Can I just jump in on the question of getting out of jury service? I received a notice, I think it was about 2 years ago, and it said on the notice that it was for a trial lasting 6 months, and just knowing that, you couldn't have stopped me from trying to get out of it. I'd have purchased a weapon on the black market and taken it in. Instead, I took in the book to show them that I knew too much about it. However, if it had been a 1 week or 2 week or 1 month trial, I'd have been more than happy to do it again. And I'm wondering, is there kind of any flexibility in the system for allowing for the difference between the duration of trials, because it's obviously, the shorter it is, the less onerous it will be on the juror.
There's some reward after the event. If you serve in a very long trial, you're usually excused then for a period of time from being called up again. But it doesn't get you out of the first one. Michaela, you were chosen as a foreperson. How did that happen?
Well, interestingly enough, my name was put forward by 3 separate people. I think my manner, my compassion, my empathy, the fact that there was some leadership, I guess, in, taking care of others around me. They felt that there was a confidence also just in my professional experience, having sat in many trials. They were homicide, not a sexual assault matter. I think that sort of instilled confidence in my fellow jurors, although we're always come from the position of we're equal. It's not about I know more than my peers. I felt incredibly privileged, even though the outcome of my specific trial was devastating to me. I have immense respect for most of the jurors that I had the privilege of sitting with, and their wealth of experience, their personal wisdoms, their strengths, with being able to help with the deliberation process was truly inspiring. So I'm grateful for that experience.
When a jury is impanelled and the trial begins, they start obviously from a position of ignorance about the case, but they're also very often, apart from those who have served before, in a situation that's entirely new, with people in fancy dress saying all kinds of things that no normal human says. And that's pretty confronting for 12 people just taken in from the community and set to work in a trial. Jane, to enable them to set about their task competently, what sort of instructions do you think should be given to a jury at the beginning of a trial?
Thank you. I do think there are quite a few. I think it's a very important phase right at the outset, the orientation for what is going to come. And I'm mindful of the fact that in his book, I think Malcolm spoke about the jury experience as quite a hostile workplace, and that the communication between judge and jury was not great in a number of instances. And so right at the outset, I think it's really important for the judge to start building rapport as a collaborator and to give collaborative instructions to the jury so that will be a shared responsibility with them to ensure that it is a fair trial all the way through. And there are a number of elements that I think are really important to that. I think some people have analogized becoming a juror as if, for example, you know nothing about the sport of cricket and don't watch sport at all, of being blindfolded, sat down in a cricket stadium, and sit through a game without knowing any of the rules and not being able to observe everything that's going on, and at the end being asked who won and why, because you're not necessarily given the rules of law at the outset. And if you don't know what is important to attend to, you may focus your attention on completely trivial, non-essential things rather than what the core action is. There are some quite interesting psychological studies on what we call inattentional blindness, where university students participated in counting the number of times that their team passed a ball, and there was a team dressed in white shirts and a team dressed in black shirts, and so they were given a point of focus. And the ball was passed. At the end, they were asked how many times was the ball passed, and then they were asked, did you see anything unusual? And they could report the number of times the ball was passed. But the unusual question referred to the fact that a 6-foot person dressed in a gorilla suit had weaved in and out of the players right across the center of the action where the ball passing was going on, and approximately 50% of the college-educated university students did not see what was right in front of their faces. And it's an extraordinarily important study because it shows that if you don't know what to focus on, you can miss things that are really salient in front of you. So I think it's critical to start by telling the jurors something in depth about the nature of the law and the nature of the allegations. And a lot of the practice has been to wait till the end of the trial to provide that information, hence that ball game analogy, rather than to orient them. And we know enough now about the kinds of misconceptions that people often bring about the law. And we know, for example, that people think that verbal evidence alone without some kind of other corroborating evidence doesn't count. So if it's a he said, she said kind of issue, many jurors disregard that because they think that it's not real evidence. Similarly, some jurors think that circumstantial evidence is inadequate. And if you have a circumstantial case and you don't explain that to people at the outset, you're going to be in trouble educating them about that at the end of the trial. We also know that many people don't really understand the concept of beyond reasonable doubt. So if they're told this is a beyond reasonable doubt threshold, that doesn't help them. They need much more guidance than that. So those are some key things. And there are more. I mean, I think that there are critical instructions about not doing independent investigations so that people will be confined from other research, and I think we'll come back to that topic. But most of all, you want to encourage jurors to be active participants. They come not as a blank slate. They come with a lot of experience that you want to capitalize on. And if you don't advise them that they can ask questions, if you don't advise them that they can take notes, that you sort of nullify their voice from the outset of the process, then you are going to lose the effectiveness of what the system is set up to really fulfill. So I think those are key things to address at the outset.
One of the things you've mentioned is beyond reasonable doubt, which of course is the level of proof that must be found by the jury in order to convict. The law is that that expression is not able to be explained any further by the court. That the High Court has said these are words of ordinary English meaning and they're not to be added to. The jury is to be told they have to be satisfied beyond reasonable doubt, but nothing more than that. So, interesting how jurors interpret that. There was a study by the Bureau of Crime Statistics and Research in New South Wales in 2008, which surveyed about 1,500 jurors, actual jurors, who had served in trials. 55% of them thought that beyond reasonable doubt meant sure that the person is guilty. 55%. 23% believed it meant almost sure. 12% believed it meant very likely, and 10% believed it meant pretty likely. So that's the interpretation from real jurors surveyed independently by Boxar.
The most common question that jurors ask during their deliberations is to ask the judge what is meant by the term beyond reasonable doubt. And you can understand their dismay when the judge says to them, I can't tell you any more. Beyond means beyond, reasonable means reasonable, and doubt means doubt. And it's for you, as members of the community, to say whether or not you're satisfied that the proof comes up to that level.
Now, Mark, there are different restrictions, I suppose, that might be described on the way in which a prosecutor or a defence counsel may address juries. Can you explain that to us a little more?
It used to be, until fairly recently, that the Crown Prosecutor would do an opening address at the commencement of the trial and then call all of his or her evidence, and then the Defence Counsel would do their opening address and call any evidence in the defence case. But that was changed some years ago to allow the defence to do an abbreviated form of an opening address immediately after the Crown Prosecutor's opening address. The purpose of the Crown Prosecutor's opening address is to explain to the jury basically what the evidence is likely to be and how the Crown structures its case to enable the jury to arrive at a guilty verdict. It's not meant to be an argumentative address, so the prosecutor is not allowed to try and argue with the jury how, if the evidence unfolds like that, they would be convinced of the Crown case. As opposed to that, the situation now is that the defence opening address at the commencement of the trial has to be limited to identifying those areas that are in dispute and those areas that are not in dispute. I think that's a shame. I think that the defence should have the option to do a full opening address at the beginning of the trial or at the beginning of their case, but not both. And I think you'd find that most defence barristers would do their opening address at the commencement of the trial, because then the jury are in a position to know both cases and how they contrast, and really to understand more fully what are the real issues, what are the real things we should be looking for when we're listening to the evidence, whereas the very restricted defence opening address that's allowed now is just, well, what's in dispute and what's not in dispute. It's just, in my view, not enough. So that's the main difference now.
Juries are told to use their common sense. What does that mean? Common sense is not all that common, as some of us have observed over the years. How do individual opinions and biases fit in, and should they be addressed in some way in the trial process? Jane, have you got thoughts about that?
I do, and I guess common sense is generally meant to refer to everyday experience, but we've learned along the way that there are some safeguards in the law that are not working as effectively as they should. So some of the clear safeguards to stop a jury from going off the rails include the jury instruction process, the deliberation process, and also an option to call an expert witness to advise the jury when perhaps their common sense doesn't align with what scientific research shows. And in recent years, there have been probably three big areas where common sense tends not to be enough. And one of those has to do with forensic scientific evidence, which is quite complex. And what we've learned is that sometimes jurors come in with diametrically opposing kinds of biases about it. Sometimes they're referred to as CSI type effects, but there is a forensic expert evidence bias scale that someone developed that shows that some jurors are more pro-prosecution and some are more pro-defense, and those two streams of thought in terms of common sense, or watching lots of CSI programs on television, have led to expectations that don't necessarily align with the expert evidence. So quite a bit of expert evidence is aimed at addressing issues where there are gaps there. At the moment in our court system, the ratio of sexual assault matters or sexual violence matters is extremely high. It constitutes approximately 85% of the criminal cases at trial in the district court here, for example. And we've learned that people have a lot of misconceptions about sexual assault, expecting people, for example, to resist it when they might freeze and remain passive, expecting victims to report it immediately when many of them delay, expecting certain kinds of behaviors from people who've experienced sexual assault that are controverted by actual behaviors. And so that's another area where common sense often conflicts what the scientific research now shows. And those might be some of the issues that were at play in some of the earlier cases. And I guess a third one that I've been most involved with recently is common sense misconceptions, they're called, about memory processes, that people expect that witnesses should have a videotape-like recording account that they can dredge up from their memory repository, and that they should never contradict themselves or have any inconsistent evidence, whereas all the body of research on memory shows that it is a reconstruction, it is a mental simulation, it's full of inconsistencies, we all make errors, and this is normal. And so it impacts the way that the evidence is interpreted and adjudged by not only jurors but also judges if you have the wrong model of how memory operates. So those are some key areas where I think common sense sometimes falls down and other safeguards are needed.
I think a lot of jurors are terribly confused by what they're told by the trial judge. On the one hand, they're told to use their common sense and their knowledge of the world. And then in the next sentence, they're told you should decide this case based entirely upon the evidence that you've heard within these four walls. Then they're told you should only draw inferences where those inferences are rationally based upon the evidence. And then they're told, well, but you should not engage in any sort of conjecture or hypothetical. And sometimes you see them, wondering what on earth does all that mean, and how do I resolve those? So we expect a lot from them.
Can I ask?
I was going to ask, did you use your common sense?
Well, first of all, I actually wanted to ask Michaela a question, if I may, on that subject. Am I actually allowed to ask Michaela a question? No, I don't mean for this. I mean legally, am I allowed? When you talk about when you talked about obviously the frustration in being a hung jury, and you said most of the other jurors you ended up with respect for, to what degree was the hung jury a result of it's just a really difficult matter to resolve because of the evidence, and to what degree was it you thought lack of common sense or some other lack among the jurors?
I appreciate your question. I think that's a really valid thing to discuss. So in my experience, I felt that cultural prejudice, lack of understanding around sexual acts and intercourse and autonomy, and just, I think also, to be honest, I feel that even though it's not the responsibility of jurors to consider sentencing, that was clearly evident in the room that there was a sense of guilt if we are to convict, what that outcome is going to be for the accused and the consequences of that. And I think that the three individuals involved were across those three things that I raised, but I think the underlying thing is we don't want to convict, and I think there was some cultural prejudice around relationships between men and women and what constitutes rape.
There was an article many years ago in the Sydney Morning Herald where the reporter had surveyed a number of jurors, and there were 4 comments that were reported. Lola used tarot cards to help her decide. Frank felt the law was wrong. Arthur, who never made notes and took the odd nap in court, had somehow managed to form an opinion. And Mary just felt sorry for the accused. So those were reports back from particular jurors, and I suppose we still get similar things. Malcolm, can jurors realistically be prevented from doing their own sleuthing, conducting their own inquiries and following the instructions of the judge to act only on the evidence that they hear in court?
Well, they can be given a persuasion. They obviously, today, it's getting harder and harder to prevent people. Although if they're under 16, you can ban them from using their phones. I think what it boils down to is, and I hate myself for the phrase I'm about to use, so please excuse me, bringing the best version of ourselves into the jury room. And my experience was, unlike probably yours, Michaela, that was what we saw. People kind of elevated themselves through being in a court, through seeing a judge. Jane, you talked about it being a difficult workplace. It only was initially. It was hard for people to settle into. Over the course of the trial, people might have been tempted to do sleuthing on day one, but thereafter they wouldn't have thought of it because they wanted to present themselves in a certain way to the other jurors, and for all we can mock the pomp of the courtroom. In many cases, it does actually bring the best out of people. And we heard about the sensational case in the Bruce Lerman trial of a juror apparently doing research, and we know how tempting and easy it is. But one would hope, obviously, we need more research to know how this plays out in reality, but certainly we would hope that the what is at stake, it's more is at stake in a criminal trial for an ordinary person than pretty much anything else, any other decision they make in their lives. It's somebody going to jail or not going to jail. And of course, justice or otherwise for the victim, if there is a victim. That in itself is very often, and certainly from the research I did for that book, that in itself is enough to persuade jurors against doing anything unauthorised.
For those who might be interested in further reading about this aspect of it, there is a publication by the Law and Justice Foundation in New South Wales, of a University of New South Wales jury study that was conducted by Professor Jill Hunter of the University of New South Wales. Jurors' Notions of Justice, an empirical study of motivations to investigate and obedience to judicial directions. And there are a lot of findings from the surveys that were conducted in that of real jurors, people who had served on juries, and there was special dispensation given to interview them for that purpose. Now, we're getting close to the end of
Can
time.
I say, Dick, that
yes, Mark.
I think the real difficulty is when we don't find out that a juror or jurors have made their own inquiries. And we know of some cases where we have found out, but there were probably cases where we haven't. And the real difficulty from the defence point of view is if an accused person has a criminal history, and there's been some publicity in the media about that in the past, if a juror does research on the internet contrary to strict instructions from a trial judge that they are not to do that, and in fact it is a criminal offence to do that, do we know whether any juror has actually done that? And they would inevitably be severely prejudiced by such information. That's why we don't allow that sort of evidence to be given in criminal trials, because it's so prejudicial. So I think that's the real difficulty, that we don't know how often it happens that individual jurors go and do those sorts of inquiries.
I'm going to just throw one last short question, and then I'll have a couple of housekeeping things I have to tell you at the end. This was an idea floated by former Chief Justice Spiegelman some years ago. Should juries have any role in sentencing? Now, this is something that happens in some of the United States of America where they have capital punishment, where juries can decide whether or not the convicted person should be executed or not. We don't have any involvement of the jurors at all in sentencing. That's a matter for the judge. Should jurors have some role to play? I'll open it up to anybody who might wish to comment on that.
I think it's so problematical. It's hard enough to get juries to agree on verdicts of guilty or not guilty. To get 12 people to agree on a particular sentence, or even a range of sentencing, I think is going to be so difficult that it's just not worthwhile going down that track.
I must say the Chief Justice was shot down fairly quickly when he put this up, but anyway.
Yeah, I remember interviewing you for this book, Nick, and you said absolutely no, and I tend to agree with you, with one caveat, and it's not a something that would change my view on it, but people have no idea about sentencing guidelines and how different they are from probably what Joe Public would expect, and certainly the difference between sentencing on crimes of violence compared with financial crimes. People have no idea how hard the courts are on financial criminals who get whacked with 10 or 15 year sentences, and then they've got a sexual violence trial where the person's found guilty and they get 2 years or something. So it would be good, I think, for jurors to know a little bit more about sentencing norms, but that said, I don't believe they really ought to have a role in sentence in the length of sentence in their trial.
You've touched on a point there. If you speak to any judge who's involved in the process, they will tell you that sentencing is one of the most difficult tasks that they face. And it is hugely complex. There are a whole lot of legislated provisions that have to be observed, a whole lot of processes that have to take place, and it is a huge job for judges to sentence in any serious case. Now, there are books available on the stand outside. Malcolm's latest book is out there. Secrets of the Jury Room is not, so you'll have to find that for yourself somewhere else. Jane's books have not made it to the stand, so you won't be buying any here, but you can get them elsewhere. Mark's 4 books are available outside, and 2 of my books are available outside too. I just mentioned that in passing. But you are very welcome to speak to any of us. You can nobble outside about what we've been discussing or about the books and so forth. And at the end of this session, you are asked all to leave the room because it has to be, I don't know, sanitised or something after we've been here. But please enjoy the rest of the festival and the discussions that you will take part in there. Would you please join me in thanking the panel?